Hi, this is Meredith Nagel coming to you, hopefully live. We are doing a presentation today on the updates to the NAR settlement. Now, just as a general overview, if you don't have any idea what I'm talking about, the NAR settlement was the result of a lawsuit wherein the attorneys for sellers alleged that the multiple listing service known as the MLS and realtors were colluding together to require sellers to pay buyer commission. And then that collusion ended up costing sellers more than they should have to pay. And unfortunately, the trial court bought that argument, and that put NAR in a really bad spot. Those of us who are familiar with real property law and real estate in general understand that the buyer's already paying his own commission in the form of the portion of the cost of the house that is attributable to the buyer's agent. But we lost that argument. We were forced then to NAR was going to have to post a bond to appeal the decision. That the bond itself, because the decision was in the billions of dollars that allegedly were owed to sellers, the cost of that bond was so high that they could not even afford to appeal. So we've had to reach a settlement. So NAR, National Association of Realtors, has reached a settlement with these plaintiffs. That settlement, the good news is that settlement protects all agents from any personal liability and brokerages as well that participate in the MLS. It protects them from liability for any allegations as to monies owed from dealings all the way up to the time of settlement. So in other words, if this settlement hadn't have happened, and if instead we had spent all that money on appeal and then lost, our local brokerages and individual realtors would have been subject to lawsuits around the country. And in fact, we saw some of those popping up in other courts before this settlement agreement was reached. So in that, the agents are now protected from liability for this alleged wrongdoing. It's a good result. Unfortunately, it changes the landscape for buyer's agents in a way, frankly, that I think hurts the little guy. And what that major change is the buyers have to themselves pay the buyer's agent commission. And as you know, our poorer home buyers, our people that are first-time home buyers, that would be a very hard swing for them. And so that's what I mean when I say that this is actually ultimately hurting buyers, and in doing that, hurting the market, not helping it. But again, I'm preaching about what's wrong with the settlement. Whatever I think of it, we're now stuck with it. So let's talk about some of the latest updates we've gotten from the settlement, and how those are going to impact all of you guys. So first of all, the changes that I'm about to go over with you have to be completed by August 17th. That is now a firm date for us because it was tied to when another event happened in the case. And since that event happened on a specific date, we now know August 17th of 2024 is going to be the effective date when all these changes are going to be made. So let's talk about what those changes are. And I'm going to kind of go in order here from least burdensome to most burdensome. The fact is there's not a whole lot of least burdensome in my opinion. So we'll talk about the least burdensome. So generally speaking, the MLS is going to be unable to provide any reference to compensation, i.e. commission, on any MLS listing. So there can be no mention at all of commissions, and most interestingly to us, what is available to a buyer's agent in the MLS for any reason, for any purpose. So they're not going to be able to put MLS compensation anymore. In addition, The MLS cannot be used as a data aggregator, for example, the way it is now in Realtor.com, if Realtor.com discloses the compensation. In other words, you're not allowed to use another website that will advertise the buyer's compensation and have that website feeding in the MLS data to go into the site. So, for example, right now, Realtor.com gets most of its information from MLS or MLS type organization. Realtor.com is not going to be able to do that anymore if it wants to be a site that posts buyer compensation. However, interestingly, nothing in the settlement prevents, and it very specifically says this in the settlement agreement, nothing in the settlement prevents realtors from advertising buyer available compensation on every other place that they advertise. So, for example, they can put it on their own their own websites. They can put it on, sheets that they pass out. They can put it on, open house description. They can do everything that you could possibly think of to advertise that this listing is offering buyer compensation. They can basically do anything that you can think of. And any other site, as long as it's not a data aggregator site, and it's no hold barred. So, stated simply, you can't put buyer compensation in the MLF, but you can put it everywhere else you advertise, including your own website or other websites, so long as those websites do not use the MLS as a data source. So the question in my mind is, what are Zillow and Realtor.com going to do? I think when they first began, they really needed and relied on the MLS for data. So it'll be interesting to see how that changes the landscape. But at least as to your own website, clearly you can put it there. And at least clearly as to any other place that you advertise, you can offer buyer conversation. Remember, I'm going to keep reminding you guys this so that this date gets set in your head. That's all has to be done by August 17th. Now, I also want to point out that the changes that we're going over that are August 17th changes, these have all been run through and made by the technology committee for the MLS and by the board of NAR. So this, there's creating and providing forms and all the stuff that we're going to talk about. And that's been through the approval process and the agreement process by the MLS and the National Association of Realtors. Okay, so let's continue on as we get into what I continue to be the most burdensome, because this is what additional thing that you guys are going to be required to do. All right, so first and foremost, you must enter into a written agreement with a buyer prior to touring a property, and that buyer's agreement will specifically require you to disclose how much money you are going to be paid to negotiate regarding that specific property. And the problem that you have, or the bad thing about it to me, is you can't use some general statement. You can't say something like anything the seller is willing to pay. You have to actually set a flat amount. And then, unfortunately, you can get no more than that flat amount. So, for an example, if you tell your buyer that you will only charge them 1% if they have to pay, you can't say, I'll charge you 1% if you have to pay, and then anything above that, I get to keep. They're stuck with the lesser of what the seller is willing to pay and what the buyer and the buyer's agent have agreed the buyer will get paid. And those disclosures have to be made before these disclosures have to be made before any property is toured. So you have to decide ahead of time. Now, remember, this one will keep you from entering into different agreements, different compensation amount based on the property you're showing them. So, for example, if you're showing them a simple property in a subdivision that will be easy to comp out, easy to do through the transaction, not going to likely to be title problems, et cetera, et cetera, et cetera. When you show them that house, you can say, oh, I'll do this house for 2%. And then if they want to see a big listing that's got many potential problems and is going to require a lot more work by the buyer's agent, checking with planning and zoning, blah, 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 you could, for that property, say, well, this one I'm going to have to charge 3% because there's so much work to be done. But in any event, before you show any property, you have to say specifically what you are willing to accept for that property. Now, this does not prevent you from having one agreement that covers several properties. So you can say, I'm going to show you these 5 houses, and for these, I'll charge you only 2%. That can be one agreement. And then you could have another agreement that says, and as for these 5 houses, I'm going to need 3%. You can do that. It's just that once you enter into agreement and set how much you're going to get, you can never get any more than that, even if the seller is willing to pay you more. So this is where it's going to be key for sellers' agents to be describing what they're going to pay off of the other websites, non-MLS, so that a listing agent can have some idea of what they could possibly get paid. And again, these decisions and agreements have to be made before any specific property can be shown. But again, I'm repeating myself so it grooves in your brain. Even if you're going to show them multiple properties, you can cover multiple properties by one agreement, but for each one of those properties, you're stuck with that percentage. But again, you can have separate agreements for separate different types of property. There's a disclosure that's going to have to be in that agreement that says specifically that commissions are not set by law and are freely negotiable. And that kind of general disclosure has to be made on a lot of places that we're going to talk about. Okay, so in addition to entering into this buyer agreement, what has to happen when the, I'm choking. What has to happen when that agreement is entered into is not only are they going to be bound by it, not only are you have to make these disclosures, but then once it goes to closing, those additional disclosures are going to be have to made again prior to close, to the extent that what the regulator, the settlement calls pre-closing disclosures, that same statement have to be made. Now, in my lawyer brain, I know that a CD is a pre-closing disclosure. It'll be interesting to see how this actually shakes out to determine, in fact, whether they mean even at the issuance of the CD, we have to put it on there. I hope not, but in any event. The other thing the buyer's agent has to do is they cannot filter listings based on whether that listing is offering compensation or not. So what I'm super suggesting to my realtors is be very careful about what you send over. And unfortunately for you, you cannot refuse to include listings that might meet the buyer's requirements just because that listing doesn't offer commission. So your buyer's agreement would still require that buyer to pay you, right? But you know in your brain that it's better for the buyer if you can get the seller to pay. That only makes sense, right? But you cannot filter out, even though in my opinion it would be to their benefit, only those listings that have that third party, compensation offer. So to protect my agents, what I am really highly suggesting that they do is keep a copy electronically of all the listings that you send over to the buyer. So you'll be able to prove that you sent everything that was could be of interest to them, whether or not it offered commissions. So you're going to need to archive that in a different way than you have before to protect yourself. Because remember this, just like there were lawyers making a butt ton of money about this before the settlement, now lawyers are going to be looking to find people that violate the settlement term. So again, my lawyer brain is telling my realtors, you must make sure you're protecting yourself and creating a record to show that you are in fact not just showing them things where you happen to know by finding out the information from the realtor's personal website or from something in an open house or any other piece of advertisement. You can't filter out just those that will be paying a commission. And I really want you to be able to protect yourself from future lawsuits. And for that reason, make sure that that gets done. What else did I want to talk to you? Oh, a question has been raised, and many people have thought, well, what do I even need the MLS for now? Why should I pay for it? What the settlement makes clear, and just as kind of a reminder, what MLS is reminding us is you cannot be a member of the MLS unless you advertise almost everything on the MLS. So unfortunately, there's not going to be a situation where a buyer's agent can just kind of buy access to the MLS at a lesser rate. If you want MLS information, you're going to have to continue to list everything on the MLS. So that place that you need to know. I've had a lot of questions like, can the buyer's agreement say up to a certain amount? No. Now, the sellers are still able to advertise concessions on the MLS. However, they have to offer those concessions even if the buyer is otherwise getting paid. So it makes it difficult to kind of get around the concessions language. So even if the buyer doesn't need the concession or doesn't negotiate for the concession, they have to get it because it was offered, and it cannot be contingent on whether they're paying their own realtor or not. So compensation generally of concessions can be discussed, but then they have to be given even if the buyer doesn't need them. So keep that in mind too. What else do I need to tell you guys about? I think that might be it. I do want to say this kind of as a closing, and I don't see any questions in the chat. So if you have those, please put them in now. Assuming you don't, I do want to say this. This entire problem was actually litigated already years ago in one of the northern states. And I'm embarrassed to tell you, all of those northern states kind of get blurred together in my head because I'm not that good in geography, but something's telling me it was Connecticut, but it was one of those kind of states where a state action was brought on these very same issues. Now, at the beginning of them having to make almost these identical types of concessions, there was a little bit of chaos at the beginning, but over time, it kind of settled out. And it ended up that buyers were still making what they did before, and buyers' agents were still making what they made before. Because, let's be honest, sellers are going to have to offer something if they want to get maximum visibility to buyers. So it's super hopeful to me that this, at the end of the day, once we get through this little bumpy part, that at the end of the day, it will kind of shake out to basically where we are right now. If anybody is watching that has any questions, go ahead and put it in there. If not, I do want to let you know that at our Lunch and Learn next Monday, we're going to be having, and remember, those are on Zoom, and we put a ton of advertisements out to that Zoom link, including on our concierge site as well as our legacy legal site. At that presentation, which is next Monday at noon, we're going to have Steve McDonald, who is the CEO, and Jeffrey Cherneau, who is the president of RASC, the Realtor Association of Lake and Sumter County. And they're going to talk about the benefits of MLS even in these trying times, and can probably answer some general questions about the settlement at that time. So I hope that we will see some of you there. If you need anything, whether you do any closings with me or not, whether you even know me, please feel free to call 352-394-7408, which is my office number, and they will get you in touch with me so that I can answer any specific questions you might have. I much prefer to help realtors stay out of trouble than help them get out of trouble. So thank you guys for watching, and to those who will be watching it later, do know that we do see those comments and will respond to them. So you can if you're watching this later, you can go ahead and throw a comment in, we will see and we will respond. Thank you for watching. I look forward to seeing you the next time.